Hello viewers, I am Dr. Ankit Shrivastava and today we will be discussing the topic of trespass to land. A tort is a wrongful civil activity that may result in harm to oneself or one's property. Common law is the body of rules that courts have formed over time and it has influenced the development of tort law. States have separate penal rules that enable government prosecutions for criminal trespass. The civil or private tort suit for trespass is the exclusive subject of this lecture today. When someone purposefully enters another person's property without authorization, it is considered trespass to land. To make this claim, merely the intention to enter the property is necessary. Therefore, your neighbors may still be held accountable for trespassing even if they unintentionally enter your lot from theirs. You may also be in violation of the law if someone brings a physical object onto your land, such as a cricket ball. Significant harm is not necessary. This means that actual harm, unlawful intent, or force are not required for trespassing to be considered a crime. Now let's talk about the trespass may be committed, how it may be committed. It may be committed by entering upon the land of the plaintiff or by remaining there or by doing an act affecting the sole possession of the plaintiff, in each case without any justification. Depending on the relevant legislation, trespassing on land can result in both civil as well as criminal penalties. It may be civil or criminal, or it may be both. It is improper and against the owner's authorization to trespass on land. Any unauthorized entry onto another person's land or property is considered trespass, and if the property owner can show that he is the owner, he may be able to sue the trespasser. Now let's look at the another point, that is proving trespass to land claim. Generally, you will need to demonstrate that 4 separate acts took place in order to establish a defendant's liability for trespassing upon the land. The first being entry. The land that is the subject of the trespass must be entered with the defendant's intention. It is not necessary for the defendant to have had malicious intent. In some areas, therefore, inadvertently accessing land might be considered trespassing. Trespassing also includes allowing anything or someone to invade someone else's property. The next point is property of another. It takes a legal interest holder in the property to file a trespass claim. A tenant or another third party could be the owner. The third is without the owner's consent. It must be explicitly or subtly unlawful to enter the property without the owner's consent. An entry forbidden sign, for instance, clearly forbids entry. It is assumed that a reasonable individual would not access a homeowner's private property when there is a private property sign. They wouldn't be entitled to such a thing. However, most residential property is subject to implied agreements for law enforcement and postal workers, so a trespass cause of action or claim would be unsuccessful in these situations. Comparably, an easement owner might have a legitimate right of access to a piece of land. And the fourth is that you'll need to show damages. In the majority of states, some harm must occur in order to prove a valid claim. This could be anything from harm to the plaintiff's property to injuries sustained, Although the defendant need not have intended to cause the harm, their conduct must have played a significant role in the harm that was experienced. The physical act of intrusion onto land, even without significant damages or harm, is typically enough to support a trespass claim. In some states, such as California, annoyance and discomfort are enough to establish trespass on land. Let's look into the concept of jus terti. It is believed that trespassing is a breach of possession rather than ownership. Therefore, a person who holds genuine ownership can sue a trespasser even if the trespasser's possession was unlawful in comparison to the legal owners. It is possible to trespass on both the soil or surface of the land and the subsurface. These different elements, like the land's surface and subsurface, could be owned by different people. Similarly, the only owner of a certain parcel of land has the right to file a lawsuit for trespassing on the surface or beneath it. However, it's possible that both parties may view the excavation of a perpendicular slit through the land as trespass, and they will each be able to take legal action. Trespassing is an offense against ownership as opposed to possession. As a result, even if the person in actual possession had unlawful possession against the rightful owner, they may still file a claim. The trespasser cannot assert that in the event of a dispute between a third party and the person in possession, the third party's title is superior by using the defense of jus terti or third person title. In Graham versus Peet, the plaintiff was in possession of the land under an invalid lease, but because any possession is a legal possession against the wrongdoer, he was allowed to file a trespass suit against the defendant for entering the property without authorization. An action can be brought by someone in possession even if they are not the actual owners. According to Baxter versus Taylor, an owner of land who does not now hold the land or have any imminent right to do so is not permitted to file a trespass lawsuit. Reversioners, or those who receive an estate back in reversion, an interest that returns to the grantor after a predetermined amount of time, may, however, file a lawsuit if the trespass causes persistent harm that will likely influence their reversionary interest. Trespassing is not limited to the land's surface. It can also occur through subsurface incursion. It is plausible that one individual may possess the surface while another may own the subsurface. The person in possession of the surface alone, not the owner of the subsurface, may file a lawsuit in such a situation if the trespass occurs on the surface. In a similar vein, only the subsurface's owner may file a lawsuit for trespassing on it. However, creating a vertical hole on the property could be considered trespassing, for which each of them could be held legally responsible. Now let's look into the nature of trespass to land. Trespass is actionable per se, meaning that the plaintiff need not prove that the trespass resulted in any harm. Every invasion of property, be it ever so minute, is a trespass. Similar to trespass against individuals on chattels, an unavoidable mishap will serve as a potent deterrent. Let's talk about when the trespass is known as trespass ab initio. So when a person enters a premises under the authority of a law and then abuses that authority by committing some wrongful act, he is regarded as trespass ab initio to the property. For someone to be admitted into a specific area without being in violation of the law, they must have done a positive act of misfeasance, that is, doing of a wrongful act. Mere non-feasance, that is, failure to do something, is insufficient. It's important to keep in mind that not all wrongdoing turns a person's lawful entry into trespass ab initio. A police officer entered the plaintiff's property in the case of Ilyas versus Passmore in the year 1934 in order to make a valid arrest. He began to remove certain documents from which he was not legally authorized, which was a dishonest act. It was decided that the police officers weren't trespassers ab initio on the property per se, but rather trespassers in reference to the paper they took out. In the case of the six carpenters went into an inn and placed an order for bread and wine. They declined to pay for that after taking it. They had committed no misbehavior, and since their failure to pay amounted to nothing more than non-feasance, there was no trespass from the outset. Now let's talk about what are the damages available for such trespass. Tenants or property owners are entitled to damages for any harm brought on by trespassing. Now the following damages may be recoverable against you as the injured party depending on the type of trespass. If it is loss of market value, cost of restoration, loss of use of the property, physical injury to the person or to the land, damage to your personal property, emotional distress, discomfort and annoyance. The loss of fair market value is typically used to calculate damages when real property suffers permanent harm. The expense of restoration or repair is typically the foundation of an award in situations of transient harm. However, damages are only given for the loss of market value when the expense of restoration or repair surpasses the decline in the value to the point that remedies are no longer commercially viable. Punitive damages may also be available in situations where the defendant's acts are very heinous. These are damages meant to penalize the defendant beyond the plaintiff's actual financial losses. Punitive damages are more likely to be awarded by a court when a plaintiff can demonstrate that the offender was aware that their trespass would cause harm. Getting an injunction. Perhaps you don't require damage reimbursement. All you want is for the trespassing to end. A court's order compelling someone to cease doing something is known as an injunction. When trespassing occurs repeatedly, the best solution is usually an injunction. So to assist you in drafting your request, numerous state courts offer forms. Consult with a lawyer or the court clerk where you can find out what has to be filed. The court will direct the trespassing to cease from following the issuance of an injunction. You have the option to file for contempt of court if the offensive behavior persists. Now let's talk about liability for injury to trespassers. So in general, neither the landlord nor the property owner are accountable for the harm a trespasser sustains. That being said, trespassers are still entitled to a duty of care from the property owner. The scenarios where a trespasser may be held accountable for harm caused by someone who is not authorized to be on your property are covered in the sanctions that follow. Under personal injury law, a property owner may be liable for unsafe circumstances on the property. Additionally, you need to be cautious of visually appealing nuisance that kids can find appealing. Owners are required by law to take reasonable precautions to keep youngsters safe who could be drawn to something exciting on their property, like swimming pools or trampolines. When curious kids trespass on an owner's property, they have an obligation to take reasonable precaution to keep them safe. Let's look into the entry with a license in someone else's property. A license grants permission to access a location with the consent of the owner and thus shields the defendant from trespassing liability. The Indian Easement Act of 1882 defines a license as where one person grants to another or a definite number of other persons a right to do or continue to do something in or upon the immovable property of the grantor, something which would in the absence of such a right be unlawful, and such a right does not amount to an easement or an interest in the property, the right is called a license. In the case of Hill versus Tupper, established the rule that a property owner cannot be sued for trespassing by someone who has permission to enter his land. The licensee becomes a trespasser on land upon the license being revoked and is required to leave the area within a reasonable amount of time. There are two types of licenses that are taken into consideration for the licensor's ability to revoke the license. First is a bare license and second is a license coupled with a grant. A license that is uncoupled from a grant cannot be revoked, but a license that is alone may. For example, a license to view a film is a license that is granted, and the authorities of the theatre are unable to cancel such a license. An example of a license combined with a grant is permission to chop down and remove a tree. In some circumstances, the licensor may stipulate in the stated or implied conditions of the contract that even a simple license will not be terminated. In the case of Wood versus Leadbitter, the defendants were the race courses occupants and the plaintiff had gone to watch a horse race after purchasing a ticket. The plaintiff was requested to leave the premises by the defendant while the races were still in progress, and when he refused, the defendant's servants forcibly removed him from the ground. The plaintiff filed an assault lawsuit. It was decided that the license had been effectively revoked, that the plaintiff had become a trespasser as a result, and that the trespasser's expulsion from the property was no longer an actionable offence. In the case of Hearst versus Picture Theatres Limited, after buying a ticket at one of the defendant's theatres, the plaintiff went to the movies. He was falsely accused of going into the hall without having a ticket and he was told to get out. He refused, so they lifted him out violently. After that, the plaintiff filed a complaint alleging unlawful confinement and violence. In this instance, the license was deemed to have been granted and could not be revoked. Because of this, the defendant was accountable for his deeds and had to pay the plaintiff. Now let's look into the remedies available. The first one being re-entry. The phrase "the right to resume possession" describes the right of re-entry. This remedy allows the immediate owner of the land to remove the trespasser using reasonable force in the event that he refuses to leave, even if possession of the property has been passed to another person for a length of time and the owner is later entitled to acquire it back. trespassing would not apply to this action. It is allowed to dismiss a trespass. In the case of Hemmings versus Stoke Pokes, golf club Hemmings, a golf club employee, received a cottage on the club's property as a perk of his work. Then he was asked to quit both the job and the cottage. Authorities forcefully entered the golf club and removed him, his family, and their belongings because he would not leave. The court viewed this as either the enforcement of the right to rent or the removal of a trespasser. Next is action for ejectment. For someone who was removed from immovable property without following the required legal procedures, this is an expedient solution. This remedy is described in Section 6 of Specific Relief Act. No one, not even the owner of a superior title, has the authority to remove another individual from office without adhering to the legal process. If he decides to dispense with the law, the individual who was disposed of will get their property back. If the plaintiff is to establish that he was in lawful possession of the property and that it was taken from him without due process, he must do so. Within 6 months following disposition, the suit for repossession must be filed. This remedy is not available to trespassers. Let's look at an illustration. For 2 days, A stays on B's property while B is away. When B comes back, A is removed from the property. Because A was only a trespasser and did not possess the land, B cannot be held accountable in this instance. Therefore, he cannot seek redress. Next is action for mesne profits. The compensation or damages that can be obtained from the individual who has been in unlawful possession of land or referred to as mesne profits. In addition to getting their belongings returned, a person who has been wrongfully removed from an immovable property may be entitled to reimbursement for any losses they sustained during the evacuation process. It is possible to file separate lawsuits for mesne profits and ejectment. Section 2, subsection 12 of the Civil Procedure Code contains the mesne profits provision. The case Square 4 Assets Management and Reconstruction Company Private Limited and others versus Orient Beverages Limited and others. The facts of this case was that as the tenant of the plaintiff's property, the defendant subleased the premises to a third party who remained there long after the contract ended. It was held that the mesne profits were computed starting on the day the lawsuit was filed and ending on the last day to vacate the property. The fourth remedy is distress damage pheasant. A person in possession of the land may take trespassing cattle or other chattels with the help of this distress damage pheasant remedy. He is allowed to keep them until the livestock owner pays him for the harm that was done. This compels the chattel owner to give payment in exchange for the livestock. Cattle, balls, bats, and other animals are all examples of objects that can be taken. However, this privilege can only be exercised if the object is unlawfully present, trespassed on, or caused damages on the land. Furthermore, once an object leaves his property or is taken away by its true owner, the owner of that property is strongly urged not to pursue it any further. The case is Borden versus Roscoe, and the facts are that the pony causes damage by coming onto the defendant's property. The pony is held by the defendant until payment is received. It was held by the court that the pony's owner is responsible for paying damages and the defendant was right in keeping the animal in custody. So, in conclusion, the law of torts designates trespassing on property as an offence. In addition to identifying the problems, the law also provides the harmed parties with appropriate remedies and takes exceptions into account. However, the ways in which these laws are applied depend on a number of variables, situations and facts, and they may vary from case to case. This law's biggest flaw is that it doesn't matter what the trespasser's motive was in any given situation. So, with this food of thought, we come to the end of the lecture. Thank you very much.